Good afternoon, everyone. Thank you so much for joining us for today's webinar, Best Practices for Contracting Between Design Professionals and How ConsensusDocs Can Help. Hello, my name is Brian Perlberg. I'm the Executive Director and Counsel for the ConsensusDocs Coalition effort located in the Washington, D.C. area, and I'm serving as today's moderator. ConsensusDocs are the only standard construction contracts written and endorsed by 40 leading design and construction associations, including owners groups such as NASPA, COA, and CURT. For today's webinar, you're encouraged to ask questions throughout the webinar, and we have allocated dedicated time at the end of the formal presentation to handle your questions, but we'll also be taking those questions throughout the presentation. Anytime you have a substantive question, please type your question in the question box, which is on the right-hand side of your screen in a dashboard type of setting. We'll also be responding to technical questions individually if you have those. Now, I'm sure your first question, or the number one question we always get in this webinar, in fact, we already got it today, is will I be getting the PowerPoint and the audio recording from today's webinar? Let me just handle that one right now, and the answer is yes. Within a week's time, but probably even sooner than that, you will receive the PowerPoint presentation in PDF form, as well as an audio recording of everything that we're saying here today. So you don't need to take detailed notes. You'll have this as a resource for you to listen at your leisure. Now, after the webinar, I'm also going to be asking you, I think you get this with the email, with the materials I just mentioned, but please do fill out the brief survey that we ask you to fill out. That will either come up on your screen at the end of the webinar or in this email survey that you receive later, because that's really helpful for us to get feedback on the content of the webinar and our speakers. Now, we have a really good audience today with lots of registrants, so I want to get to it for our webinar topic today. And we've got a really balanced, diverse group of people who have called in today, which is really always good to see. Now, let me introduce our speakers who are the main stars of today's webinar. First, let me start with Charlie Rogers. Charlie is a partner in the Atlanta office of Smith, Curry & Hancock, where he is a partner that focuses on representing all parties in the design and construction process, and he provides advice and advocacy for all phases of projects, including pre-project planning, development, contemporaneous management, and resolution of project-specific disputes and claims. Charlie is actively involved in providing consultation relating to government contracts compliance, including issues raised by the Federal Acquisition Regulation, or the FAR. He's been named by Law and Politics and Atlanta Magazine as a rising star and one of Atlanta's best lawyers under 40. Charlie was the chair of the working group that successfully drafted the ConsensusDocs 250, which is going to be the standard document that's going to help guide some of the best practices in contracting among design professionals that we'll be talking about in more detail today. Let me just personally thank Charlie for his leadership and active involvement in providing the subsequent guidance on drafting the ConsensusDocs 250. Next, Charles Vantine. Charles is a partner in Denton's Construction Practice Group in St. Louis, Missouri. He represents a wide variety of clients and advises them on all phases of the project, including contract drafting and negotiations. He regularly counsels clients in real time through the course of construction as issues arise on the project. He's handled complex issues and multi-party disputes at the state, federal, and appellate level, as well as dealing with alternative dispute resolution procedures such as mediation and arbitration. He's named the Missouri and Kansas Super Lawyers Rising Star in 2011 and 2012, and then just this past in 2013, he was nominated and named a super lawyer for Missouri and Kansas. Charles served as the vice chair of the working group, along with Charlie, on drafting the ConsensusDocs 250, and did a great job, and did a particularly good job on the insurance provisions that you'll see in the standard document, which we'll also be providing you as a sample with the email that I mentioned. So let's click here. This one. All right, so let's talk about today's learning objectives. We're going to discuss best practices for contracting between the lead design professional as well as the consultant design professional, and that's really the focus of our conversation today. We're going to understand how the ConsensusDocs 250 standard agreement addresses unique risk management issues that both impact the lead design professional and the consultant. And then we're going to use those to understand key contractual clauses for design professionals and consultants and things that they really should discuss before beginning their project and ending contract negotiations. So before getting into the substance, I just wanted to give a brief background about the ConsensusDocs coalition effort so you can get a flavor of what led to this effort, why we produced a standard document, and what's sort of the driving forces behind that. So here is a picture of the 20 organizations that were part of the original publication back in 2007 of the ConsensusDocs standard documents. And this is the first time in the United States where there's been a broad coalition of endorsing organizations that had an equal say and voice at the drafting table to create a standard document that would identify best practices and fair risk allocation at the national level so that you can then use that as a better basis and a foundation for better project results that you can then modify for your specific projects. Before this, it really had never been done before. Certainly standard documents have played an important role in the design and construction industry, but they were really emblematic of one association's particular strengths or weaknesses, and there was always a perception issue of whoever the one association producing those standard documents would seem to favor the parties that association represented. So what was thought of, hey, instead of having these lengthy negotiations that are repetitively trying to negotiate the same unfair clauses, let's try at the national level to reach some sort of consensus so that it would benefit the industry. So that was in 2007, and we made the cover of E&R when we were successful in actually publishing 70 standard contract documents. And then flash forward to today in 2014, it's been a real success story. It was a real success story reaching out there to try to come up with a better way of doing standard contracts to benefit the industry. We've doubled the number of endorsing organizations. There's actually 41 now organizations that have endorsed the ConsensusDocs document and who are actively drafting. We have a lot of owner groups. I think I mentioned at the outset, we've added owner groups. We've added groups that have more of a design professional focus, such as Construction Specifications Institute, who are certainly impacted, their membership certainly impacted by the ConsensusDocs 250. But you know, we want to be adding endorsing organizations, and we've doubled the amount of users and subscribers of the ConsensusDocs if we weren't onto something that was really benefiting the industry, and that's very encouraging. And actually in 2014, I'd say I'm seeing the acceleration in the impact that we're having, which is also very encouraging as the overall design and construction industry is primed for success going forward. It maybe not as fast as we would all like to see, but we certainly see a positive recovery underway in construction. In fact, we just saw unemployment numbers that after being in the high double digits, getting close to 20% in unemployment, we're now, I think, in the construction industry at under 6.5, which is encouraging. So ConsensusDocs, we came out with 70 documents to begin with. Now we're over 100 standard contract documents. We organize them by project delivery method. Today we're going to be really talking more about the default in the industry for design bid build, or we like to call it general contracting, or the traditional delivery method. Those are all documents in the 200s. The 250 would be an example of that, which we're going to focus on today. But we also have the owner design professional, which would be the lead architect or engineer, as the 240. That'd be the long form, or the 245 would be the short form version of that. And then we even have other documents that help owners and design professional contracts, such as the pre-qualification statement, being the 222. ConsensusDocs was the first to publish a standard integrated project delivery document, which would be the ConsensusDocs 300, as well as the first to come up with the building information modeling standard documents that's very well thought of, and the first to come up with and that'd be the 301. And then the 310 would be the Green Building Addendum, which was really the first document to comprehensively address the unique risks in a comprehensive fashion for green building construction. 400 series design build, 500 series is construction management at risk. 700 would be subcontracting. And then 800 is CM agency as well as program management. So, I like to say is if there's a contract you need, it's like that old spaghetti commercial for Prego spaghetti sauce. Hopefully it's in there, and if not, we'll be working on it in the future. And if you have any suggestions offline, please feel free to forward those if there's something that you do think is an industry need that isn't currently being addressed. So just a quick overview before I hand it off to Charlie about the ConsensusDocs 250. It was one of the documents that we didn't have either in 2007 that we realized, hey, if we want to have a consistent flow down issues from the owner contracting with the design professional, we need to make sure that the design professional is able to have a consultant agreement that is consistent with that. But we also wanted to come up with something that is flexible enough to potentially be used with other manuscripted or other documents. But certainly the main focus was to making it sure that it's going to be consistent with within the ConsensusDocs family of documents. And then we basically used the same rules of the road that has been successful for this broad coalition to come up with documents that ultimately govern their members' performance on a project. And that is, we're looking out for the best project results by having fair allocation of risk. And then we want to make sure, and you're going to hear about this throughout, to make sure that the provisions are flowed down consistently and fairly based upon the prime agreements. So for this case, that would be the 240 or the 245 owner design professional agreement. As I mentioned before, we had a really good working group to create the design, the 250 for the design professional consultant agreement. In addition to the two Charlies on today's call, Mike Lapicola, an attorney in Minnesota, was also vice chair. But we also had a great working group that represented consultants and engineers and contractors, and getting a broad range, and owners, of course, getting a broad range of feedback. And I think, in particular, I think Tiffany Arnold, who might be joining us today on the call, was very helpful in providing constructive feedback to make sure that we didn't have blind spots and that there was a holistic evaluation of risk. And that's really our competitive advantage, is by listening to a diverse group of folks and really listening to them at the drafting table. But that ultimately that puts you further down the road in coming up with a better work product, and hopefully that helps your project results down the road. And with that, Charlie Rogers, let me ask you to start highlighting some of those unique issues.
All right, thank you, Brian. Before I get started into substance, just a brief moment to say thank you to Brian Perlberg and the good folks at ConsensusDocs, as well as the rest of the working group, for their efforts to assist the rest of us in coming up with this document. I think it's instructive, and Brian touched on this, but the intent in putting this group together and then the work product that came out of the group was certainly focused on learning from the experiences of those of us who have, for lack of a better term, to use a tired old cliche, spent a lot of time in the trenches in the context of this particular relationship, that being design professional and consultant. And the overwhelming agreement from the group was that in order to develop best practices, we really needed to focus on a couple of key points. Above all of them, fairness in risk allocation. That's really what we spend most of our time at least arguing for when we are negotiating these documents, and therefore we put our efforts into that direction. Now, we also had a shared experience in that too often this relationship, when it comes to contracts, was a bit neglected. We either had a lot of experience with design professionals who would go to great lengths to negotiate the contracts they would execute with their owner clients, and then they would rely upon unexecuted letter proposals with their consultants, or they would send a standard form agreement to a consultant and never execute it, or fail to properly negotiate the important terms. And again, with a focus on best practices, we are looking here to identify some of the specific areas that most frequently are at issue and that can most frequently become problematic as between the design professional and consultant, and to talk a bit about how to avoid some of those problems. Now, Charlie and I have done this previously, and we are going to engage in a bit of a back and forth. We have loosely assigned roles to each other in that I will be frequently commenting on the perspective from a design professional's, the design professional's perspective, and Charlie will talk at some points on how a particular issue might be affecting a consultant. But of course, we probably will go in every which way in all directions once we get into it. So, addressing the issues here identified on the first slide, one of the most important ones that we don't have here is the fact that as between these professionals, they are each charged with very separate and distinct design disciplines. That can be a real concern for the lead design professional, if it's an architect in particular, but also as an engineer, in that often their consultants are performing a level of technical expertise that they may be vaguely familiar with, but they are certainly not capable of addressing on their own or even evaluating sufficiency on their own. That is one of the subsets of the overall relationship issue between these two that really stems from the upstream issue between the owner and the design professional concerning cost and oversight. From the design professional's perspective, of course, they want to be very clear in their contracts in delineating exactly what type of oversight, and that's just another word more or less for contract administration in practical effect, that will be performed under their scope, and they want to be very explicit about the cost that will be received in exchange for it. Whereas owners very frequently want to ensure the maximum oversight for a minimum cost. This is the real push-pull of this relationship, and in the working group's collective experience, we found that too often the design professional and consultant didn't adequately address this issue and did not spend the time necessary to establish or determine the proper balance for the two of them to seek with each other when negotiating their agreements. Obviously, redesign issues are an important component of this. Owners will almost always assert that redesign, if it's necessary for anything other than an owner-directed change, should be included in basic services. Design professionals will vehemently argue against this, but most specifically, what we were looking to do is provide the parties with something that would allow for consistency. And I think overall, consistency is probably the most repeated idea and term that the group came up with and discussed as we worked through here. And obviously, we want to ensure that the prime agreement that establishes the terms and conditions between the owner and the design professional is properly and adequately reflected in the downstream agreements between the design professional and the consultant. Again, the uniqueness of this relationship, that most frequently is going to assert itself in the context of the deliverables that each produces, with the exception of ensuring proper coordination of them. But most frequently, it's going to show up in contract administration. All too frequently, design professionals enter into agreements and discover during construction that their consultants are pointing to something in their proposals that says their services are going to be extremely limited during construction. That presents an obvious problem. The design professional is not capable or qualified on its own to assess the adequacy of structural work, oftentimes the adequacy of electrical work, mechanical work, and therefore must rely upon their consultants. This is going to be a consistent theme and a recurring theme throughout this discussion, because this group really did focus a lot of effort and attention on ensuring that the relationship addressed and accounted for these contract administration issues in the proper way. Now, moving on to the next slide. Here we have a listing, and these numbers correspond with the provisions in the ConsensusDocs 250. But this is just a list, not exhaustive by any means, but a list of the highlights based upon the provisions in the agreement that are most frequently the subject of negotiation in the context, in the context of negotiations between the design professional and consultant, or in the absence of those negotiations, which again was all too frequently something that all of us had experienced, problems that arose during the course of a project between the design professional and consultants. And we're going to go through and address or touch upon all of these items. Again, not an exhaustive list, but these are the areas that are most frequently the subject both of negotiation and dispute. Next slide, please. Now, as I mentioned previously, consistency between the prime agreement and the consultant's agreement was, above all else, something we really strove to focus the terms and conditions of this agreement. And obviously, when we refer to the prime agreement, we are talking about the agreement between the design professional and the owner, which establishes not just the design professional's scope, but also the terms and conditions under which the design work being performed by not just the design professional, but his entire team working under him as consultants will be provided to the owner. The easiest way to do this, obviously, is to make an effort to flow down the requirements of the prime agreement. There are a number of issues that come up in this context, and we're going to get into some of these in particular, but for the most part, we were looking at flowing down the prime agreement provisions to not leave gaps in the services that are promised to the owner, and these can be gaps in scope, gaps in responsibility, gaps even in liability, or something as mundane as gaps in insurance coverage, which certainly could lead to problems with the latter two items. Now, based on the collective experience of the working group, we found that problems and difficulties in the relationship stem more from a lack of consistency than virtually anything else, with anything else in the context of their contractual agreements. The reality is that most projects do rely upon standard form agreements between these folks, but as I mentioned before, often those agreements may not be executed or may not be adequately negotiated, and the terms of those agreements, when people get done modifying them, vary extremely widely. We were looking to sort of short-circuit that process, come back to some consistency, and come back to consistency in a manner of fair allocation of risk that would remove or alleviate the need or the urge on both parties' sides to undertake that kind of extensive modification of the standard terms.
And Charlie, this is Charlie Vantine. I just wanted to jump in for a second before we moved on. It's probably fairly obvious, but of course, this 250 that we are working on, the point was that it would be easy to use with both the long form 240 or the short form 245, and the intent of the 250 was to make it, as Charlie mentioned earlier, flexible, but also fairly short form in and of itself, to make it easy to work with, easy to negotiate, and make it so that it's not a big ordeal for the design professional and consultant to get it done quickly.
Yeah, I certainly would second that. I think we found that a lot of times the path of least resistance was more or less what led folks to simply rely on a proposal rather than try to negotiate an agreement, because too many of them have had the experience of taking a 23-page standard form and turning it into 50 pages after the lawyers get through with it. So again, not to repeat myself, but this won't be the last time I say this, consistency in the documents is worth mentioning again and again and again. It's the most simplistic mechanism by which to achieve consistency in the relationship and consistency in the provision of services, such that no one is left disappointed, and that includes the end user, the owner, for whom all of these services are being provided. Now, with respect to the flow down, there are potential issues there. It's not as simple as it may seem, because there certainly might be things that are left out. We need to all remember that the design professional has more and different obligations than each of its consultants, and therefore everything that's in the prime agreement is not going to be appropriate for application to each of the various consultant agreements, and that's going to require some effort to identify those and to single out the ones that need to be exempted. Obviously, it's always a good idea to avoid promising what one cannot deliver. Again, that goes to the idea that the individual consultant agreements need to be mindful of the issues that are affected or that do affect their scope of work, how the terms and conditions binding the design professional in the prime agreement apply to those services that the consultant is providing, and how those other provisions may not affect that relationship. The most problematic area in dealing with the flow down, of course, is to determine what specifically negotiated concessions may exist between the design professional, the lead design professional, and the owner. Those could be problematic to the consultant vis-a-vis their relationship with the design professional. Among or above all else, they certainly need to be identified, discussed, and negotiated between the design professional and consultant. It's typical and should be expected that by the time the design professional gets around to executing its contracts with the consultants, very frequently the agreement with the owner has already been executed. It's not always the case, however, and in an ideal situation, the design professional has had the opportunity to discuss a number of these issues based upon a proposed contract from the owner with its consultants, arrive at a consensus opinion on a counter proposal, or which provisions might be acceptable and which might absolutely not, and to present a unified front to the owner in an effort to avoid having that variation in the expected terms as a result of negotiated concessions the design professional ends up making to the owner.
From the consultant's perspective, certainly it's vital to make sure that you get a copy of that prime agreement, whether fully executed or not, to make sure that the consultant is fully aware of the risks going into it. The other thing I wanted to point out was that one of the things that we wanted to make sure was also consistent in the flow down was the standard of care provision in this section 1, in which we don't utilize a heightened standard of care, but rather, the more typical standard of care of, services performed by the consultant performing similar or the same work on a project of similar size, scope, and complexity during a time, location where the services are provided. And that would be another area within the flow down to make sure that there is some consistency. And of course, that would inure to the benefit of the design professional to make sure that there's consistency there if for some reason in the prime they are subjected to a heightened standard of care.
Yeah, those are some very good points. And despite the fact that we may all understand and acknowledge that there simply, as a practical matter, is no such thing as a higher, highest, or greatest standard of care, that doesn't mean a problem cannot arise if one of the parties agrees to be bound by such a non-existent standard. So it certainly inures to the design professional's benefit, in addition to the consultant, to make sure that the consultants are all aware of this agreement, all aware of the terms that are being contemplated, such that a discovery of a problematic provision is not made during the course of construction. The most obvious example of that type of issue being a discovery well into the project when there might be a problem arising that the consultant doesn't have anywhere near the required amount of insurance coverage. And another, in a different context, another example of this potential difficult problem with the conflict of terms, I think it's an analogous situation when you look at how frequently we see owners and contractors significantly modifying their general conditions to the contract for construction, which have extensive provisions detailing what the design professionals will and will not be doing, and very frequently those provisions are edited, yet no one ever thinks to go and look at what the owner-architect agreement, which typically precedes the contractor's agreement, often by many months, says that the architect will actually provide. So it's this lack of coordination that can lead to some real significant problems during the project. And again, these are going to show up during contract administration, not so much during the design development or construction document phases. So the other aspect of the flow down is the priority of documents. And here we're talking about the event of a conflict between what the specifically negotiated terms of the design professional consultant agreement says and those of the prime agreement between the owner and the design professional. This was one of the areas where the working group had a real great discussion and debate amongst itself, and I think that was owed to the fact that we had representatives from all corners of the industry involved and got all of the good perspectives here. And ultimately, the parties, I think, came to an agreement. It may have been an uncomfortable agreement for some people, but ultimately the 250 came down on the side of having the consultant agreement control in the event of a conflict, for the simple fact that this is the agreement and the document that both of the parties at issue negotiated and signed, as opposed to the prime agreement, which in many cases the consultants don't have any opportunity or say in what is agreed to or negotiated. The takeaway here, of course, is that the priority of the prime agreement is something that can be negotiated still. It's not necessarily default, and in the 250 we've got it the other way around. There is, however, an important point here that everyone should acknowledge that the design professional certainly has the most to lose in the event of conflicts or gaps in scope and responsibility between the owner agreement and the agreements with its consultants. Careful editing and negotiation based on the obligations owed to the owner is something that the design professional should very frequently be focused on, particularly if they intend to leave the provision as it has been drafted here, which is that the agreement, the consultant agreement is going to control in the event of a conflict. And obviously the kind of conflict we're talking about is where the design professional has promised something to the owner, and as that flows down to the various consultants' scopes and their design disciplines, if that deliverable is not there, then the design professional has a significant problem.
And to expand on that just a little bit, this provision, if you're representing the consultant, this provision shouldn't lull you into a false sense of security, because while in the event of that direct conflict, Charlie's exactly right, that you get this this application of the agreement, the 250 actually governing. But the problem is there are obviously going to be provisions within the prime agreement that don't directly apply, and there could be things in there that that would straddle the consultant with those additional obligations. And so again, just don't let it lull you into a false sense of security.
So the next aspect of the flow down and the priority of documents concerns the scope of the agreement between the design professional and the consultant, and that usually is going to show itself most frequently in the context of the consultant's proposal. Another area that was discussed at great length in the working group, and it really came down to one question: do you incorporate the consultant's proposal into the agreement in its final form, or do you not incorporate it? It was a difficult decision. There were perspectives on both sides of this. But again, getting back to the end goal of the committee and the real focus here of a fair allocation of risk and collaborative processes, which really is something, just to throw a plug to ConsensusDocs, I think more than any other standard form family of documents, the ConsensusDocs documents really do proceed from a perspective of collaboration. And as all parties to the industry move more toward the collaborative processes, these documents work very well. And with those goals in mind, making the contracting process for the parties here easier and clarifying intent, interpretation, and supremacy issues that often arise, we came down on the side of having an incorporation only with respect to the technical particulars of the services to be provided by the consultant. So the proposal helps establish the specific details of the scope of design service to be provided. And to that end, as you see from Section 1.2 of the 250, even though the language in there says that the consultant's proposal shall not amend, vary, modify, contradict, et cetera, the terms and conditions of the agreement, we've got the disclaimer there, other than the description of services contained in Article 6. So the option of including as an exhibit to the 250 a proposal that may or may not go far beyond a specific technical description of the services to be provided. The language in the agreement itself takes care of any issue there by making it very clear that other than those descriptions of scope, the terms of the agreement are going to supersede the proposal and anything else it says. So there's no issue for the design professional to worry about. Did they slip in a $25,000 limitation of liability that I've got to be concerned about? Doesn't matter You're not going to get caught by something like that in a proposal just by including it as an exhibit to the 250. Because the language is explicit, we tried to address that problem very clearly and hope that we did so, but it was the overwhelming consensus of the group that certainly none of us as counsel who work with these contracts, nor our clients who know much more about the substance of their practices as design professionals, wanted us to get involved in the drafting process of a description of scope. So this allows that to be taken care of by the consultant, much as it would be if the consultant and the architect, for example, were contracting without the involvement of any lawyers, like the old days, perhaps. And we can do that with the 250 as drafted by simply making it very clear that no other terms of the proposal are going to be transborted.
And this really was one of those ease of use considerations that we were just hoping would make this agreement a very streamlined process. Next slide. All right, there we go. So when we were looking at the insurance provision, we started with the premise that we should probably make sure that the consultant has insurance. While that may seem like sort of a novel concept with respect to form agreements, oftentimes what we see in the industry is that when if agreements aren't used and the proposals are simply used, perhaps you have one line about the consultant will carry insurance, adequate insurance, right? Or maybe it won't mention it at all, and then there's uncertainty there about what coverages may or may not exist. So the goal for the working group really started on two premises. One, we wanted to have a set of explicit requirements and that the parties would have to sort of take a look at and review and compare to the upstream agreement to try to review those explicit coverages. And if you look at, we have a fairly general statement in Article 4, but where we have the actual language with regard to the coverages and what would be filled in limits is set forth on Exhibit D. And the point of that then was to avoid that general provision, which is just that the consultant will have some insurance, or maybe you would set out the limits on one typical or one kind of insurance like the EO coverages. We wanted to make sure that all of those things were set forth so that they had to be considered to make sure that there was consistency, there's that word yet again, on coverages, limits, subrogation, whether or not there's a waiver there, and any other requirements that may be set forth in those coverages. So primary goal, no gaps in the insurance coverages. And this really works both ways, because from the design professional's point of view, obviously they don't want to have an upstream claim from the owner that there isn't adequate coverage for downstream if there's consultant liability. And of course, from the upstream direction, the consultant isn't going to want to have too little insurance or not have certain coverages, tail coverages, or whatever else there should be, because as we all know, just because there's not insurance coverage doesn't mean that there isn't a claim. And the lack of adequate insurance coverage can lead to the demise of a small consulting shop, because quite frankly we all know that if there was a claim that was successful, then once the insurance runs out, well, then you go after the assets, right?
Yeah, and we certainly are starting to see more and more with owners and contractors, I think, again, with the eye toward more collaborative processes in development and construction of projects, the use of more comprehensive and sometimes much more complex insurance packages, whether it's an OSIP, a CSIP, an OPPI, or something else that is packaged together. These things often come with absolute mandates with respect to the coverage required for all design professionals, and this can get specific down to a landscape architect, and you don't want to be in a position like I have been recently with a client where I represented one half of a joint venture on the owner-developer side, and the other half, who was putting on the developer hat, had engaged each of the consultants and design professionals, and with the exception of the lead professional, had nothing more than signed letter proposals for all of them. Well, in addition to the fact that they had a number of limitation of liability problems in them, if the limitations are going to be for the amount of insurance coverage, that's one thing, but if it's going to be for the amount of a $27,000 fee or for a $50,000 fee, that's another one. But most problematic about all of this was that the absence of executed contracts violated the terms of the OSIP that was being put together for this project. As one might imagine, having to go back to all of these professionals after the fact and explain to them that they did not have much of a choice and had to execute agreements with the appropriate coverage amounts, which necessitated a number of them going back to increase their coverage after the fact for work they had already provided, created a lot of unwanted and unnecessary tension at the outset of this project.
Charlie, did that also include cost increases? Because I see that quite often too, right? As we go through the various limits, and that can be that can completely take away the margins for the consultants.
Yeah, and then it comes down to the mercy of the owner or developer and whether they want to allow the increase that would have been built in on the front end had the professionals known that they would have these additional premiums or had these additional insurance costs. But after the fact, they don't know it. So yeah, that's a real significant issue for the design side of this. And again, something that if attention and focus is paid at the outset to what requirements are in the prime agreement, what issues there might be with flowing down those requirements, and ideally where there are specific insurance issues that are called out, those absolutely, for the benefit of both the design professional and consultant, need to be passed around and discussed in advance.
Okay, next slide. The next area of focus was the cost estimates and whether or not there was going to be any such obligation in the 250. And, you know, stepping back, overall, design professionals and consultants alike aren't overly inclined to provide these types of services. It's not something that they really want to do. And there certainly is a push-pull then with the upstream parties, particularly the owner, because the owner wants these types of services, right? So as we looked at this provision and decided how we wanted to handle it, we did it as a sort of a contingent provision, which is there is no independent requirement here in the 250 for the consultant to provide those types of cost estimating services. However, if there is such a provision within the prime contract, the prime agreement that requires that type of scope, then the consultant likewise shall undertake those obligations, which would include, you know, assisting in the preparation, review, and approval of those cost estimates, and at least the portion that concerns the consultant for the design professional's overall cost estimating relative to their scope of work. The other component of this provision then had to do with redesign obligations relative to whether or not those cost estimates ended up actually coming to fruition with respect to bids. And we took sort of a compromise position because the goal was to not inundate the consultant with having to have an affirmative obligation under this agreement to redesign more than what really should be allocated to that consultant. And so in that, we were trying to, again, go for that fair allocation of risk. How we ultimately decided to handle it was that if the negotiated proposal ultimately exceeded the cost of the construction by a certain percentage, if it was within a certain percentage of that cost, then the consultant would not have any additional obligation to move forward with any redesign without getting additional compensation for that additional work. And so our thought process was that the consultant really only has a small sliver of the actual overall cost estimate, so we didn't want to saddle them with, again, having to redesign to help the architect for portions that may not have anything to do with its scope. So this was a compromise position in order to still have the ability to require if the cost estimates are way off, But if they're within a reasonable margin, which the parties will have to sit down and quite frankly think about what they want those margins to be. But if it's within a reasonable margin, then there would be no obligation, if required at that point, then the consultant would be entitled to additional compensation.
Yeah, and an ancillary benefit that I think arises from this provision is that we remove yet one more item from the potential smorgasbord that is available for a dispute over whether something is additional services or basic services. And as everyone who's been involved in these situations understands, it's extremely common to get into that debate in slightly different contexts, redesign for compliance with applicable codes and laws, or redesign in order to comply with the contractual requirement that work has to be accepted and approved by the owner. Redesign for compliance with the owner's stated cost objective is another area where there can be tremendous disputes, because this, depending on the situation, could turn into a tremendous amount of additional time and a tremendous amount of additional work in the design phase that neither the design professional nor his consultants have allocated. So by doing this in the percentage format, it forces the parties to think about it. It forces the parties to reach an agreement about it, and then it eliminates any confusion or potential for dispute down the road. All right, so continuing on with the specifics of the scopes of service, and again, remembering that we're dealing here with the overall issue of cost versus oversight. Now we're getting into some of the administrative responsibilities, and what we tried to do here is be specific. I think the sections that we've identified here on this slide are all the standard and typical administrative tasks, and that's providing interpretation and clarification for contractor RFIs. All of these are tailored to the consultant's specific scope, of course, but providing some framework within which to address each of these, again, very, very typical administrative functions, assisting the design professional with change order requests, again, limited to the scope of the consultant, assisting the design professional with the review of pay applications, again, tied to the scope of the consultant. And these provisions, again, were intended to allow for consistency with the design professional's obligations to the owner. And remember, from the design professional's perspective, they owe the owner a complete performance on every one of these aspects with respect to all components of the design scope. And if it's a project where the design professional has lumped all of the other disciplines underneath his contract, then he's responsible to provide adequate interpretation and clarification and respond to RFIs, not just for his architectural, but for MEP, for structural, for civil. Same thing for submittal, same thing for change orders, same thing for pay application review. All of that can really put the design professional in a bind if they have not adequately accounted for the need to spread this amongst the consultants and ensure that the consultants have the obligation to perform those tasks via their contract. And this, this really leads to what are the costs associated with the consultant performing more intensive on-site services as you get down the road, not just professional costs, but reimbursables, logistics, all of these things that we try to address here in the 250. As we get in here to the next slide,
okay.
We've got specific provisions.
Before we get too far.
Yeah, right here. As we get into the project, we're not dealing so much with things that can maybe be dealt with on via email or over the phone. A lot of responses to RFIs are taking place that way. Same with the review and approval of pay applications, change orders. All of those things can frequently be done without on-site representation. But ultimately, you're going to get to the question of on-site representation, on-site obligations. And this is an area that typically we felt was underrepresented and under-negotiated and simply not thought of. too frequently between the design professional and the consultants. Again, from the different perspectives, it certainly behooves the design professional to ensure that they have not just adequately protected themselves with respect to getting the consultants involved on some of the office administrative stuff, if you will, but most particularly from on-site. The ability to achieve the transparency that benefits both parties to this so well is best achieved by specifying all of the expected visits, all of the expected meetings, all of the inspections that will be undertaken. And I use the word inspection, fully aware that it only applies to determining dates of substantial and final completion. Last time we gave this, I failed to make that disclaimer when I mentioned it, and we had some irate questions at the end. So I'm going to say that now, as well as warranty visits. All of these on-site obligations that very, very frequently the architect is scrambling to cover on its own, often beyond one visit that might be thrown in a consultant proposal. So the design professional is going to get squeezed here pretty quickly if they're going to get a bill for additional services from their consultants for these functions that weren't anticipated, and thus we wanted really, really strongly to make sure that this was an area of clarity as opposed to the murkiness that it has often been cloaked with in our experience. So we're then to get into issues of attendance on site. This comes up with, as I mentioned earlier, looking at some of the logistics. Are some of these things issues that can be accomplished, tasks that can be accomplished remotely? Maybe for meetings, OAC meetings, sometimes that could be accomplished. For a site walk accompanied with the review of a pay application, I would submit that would never be acceptable in the eyes of most folks who are assessing standard of care. But all of this is addressed, if we go to the next slide, here in the 250, by providing not just specifics and broken out specifics with respect to worksite visits, project meeting attendance, site visits for inspections to determine substantial completion and final completion, and warranty period visits. All of these things are broken out separately. And I think the thing I like best about it is that these are left blank. It's not the ambiguous stage appropriate to construction or number of visits appropriate to the stage of construction. It's none of the vague or ambiguous language that gets people into trouble, but a specific issue here allowing for the parties to negotiate. And again, this leads them to look, well, what is the owner going to expect from the design professional? Well, it stands to reason that you, at a minimum, want to ensure consistency with those numbers, but forcing the parties to agree upon it in the context of recognizing that there are these separate and distinct obligations is half of the battle.
And with respect to those site visits, that's an issue that can make or break financially a project for a design professional or a consultant. And oftentimes, in the prime, maybe there are enumerated numbers of site visits, but even if there aren't, the architect is the lead architect is typically fully expecting to make appearances on site and things like that, and they incorporate that into their pricing. It's less common on the consultant side to have the expectation of needing to be on site, particularly if there is an expectation upstream that, oh, the consultant is supposed to be on site quite often. And I had this recently with a set of projects that I've been working on in Mexico and the Caribbean, where and these are hotel projects where the consultant, which we needed to go down on site, travel from the U.S. to get down there, it was a huge expense because they're having to, purchase airline tickets on relatively short notice for quite a bit of money, and of course you have the flight time and all of that. Expense-wise, for the size of the agreements that we had, it really was a big deal. And had we had something like this that made the parties think about that, I think a lot of the angst that was created by that really could have been avoided.
Yeah, and a similar experience that I'm dealing with at the moment involves an architect who's the lead design professional whose agreement contemplated 1 visit per month for the duration of construction, and oh no, the consultants each had 1 visit promised for the entirety. And then you add to the fact that a 9-month project became a 17-month project due to a number of delays, and there was, as you might predict, an extensive dispute and ultimately some litigation about additional services and the suspension of services by more than one of the design professionals due to non-payment.
All right, so the next topic, which is always a big one in the design realm, is the concept of additional services. And this is again, another one of those big issues that really can make or break a project. And the upstream parties are always trying to squeeze as much as they can out of the basic services, and the downstream parties see things quite a bit differently oftentimes, and want to tack on the additional services in order to get the additional compensation. So there's the obvious economic push and pull there. What is often seen in these types of agreements is the typical authorization required type language, and we do in fact have that, where prior to commencing with any additional services, the consultant is supposed to be able to, or is supposed to obtain written authorization from the design professional, which of course shall not be unreasonably withheld. Oftentimes that's the end of the conversation. The working group, though, thought that there may be instances where it made sense in order to allow the consultant to move forward if the consultant felt that it was absolutely necessary to do so. We lump these in as quote-unquote emergency services, which are really supposed to encompass services that the consultant believes are additional services that it believes are necessary for the compliance of the standard of care, right? So very important to the consultant to make sure that they're doing what they are supposed to be doing under the obligations of the agreement and quite frankly, the law. And secondarily, to ensure compliance with any scheduling requirements for which they may be liable down the road. And so we term those as emergency services, and basically the overall concept is that the design professional would provide notice, and that by providing that notice, thereafter they are entitled to negotiate with the design professional in order to get paid for those additional services. And in the event that there can't be an agreement made, that it then refers to Article 13, which is our dispute resolution provision.
Yeah, one clarification: it's the consultant, of course, that provides the notice, and that serves the architect or the lead design professional with the signal that there is something being provided that the consultant believes qualifies as emergency, and then the text of that section leads them through the rest of that resolution. Generally, on the issue of additional services, obviously the most elemental way to avoid any disputes here is to be explicit about what is basic services and what is not. And really the best practice to avoid disputes is to be extremely detailed in the exclusions from basic services. That obviously leaves no doubt. Beyond that, we're looking at 2 goals here: an explicit understanding, arriving at an explicit understanding on both parties' behalves of what is included in basic services and what is not. A lot of that can be accomplished by the attention and effort put into the flow-down provisions with the prime, as well as the obligations the lead design professional owes to the owner. Those discussions engender a lot of discussion about basic services and additional services and what's included in each. And then the second goal, if you arrive at a determination that something is going to be an additional service, we want to have a meeting of the minds in advance of the service being provided, if at all possible. That way, there is agreement between the consultant and the design professional when that's sent upstream, and both parties are satisfied that it's not going to be met with an objection or a dispute, because one of the many things owners hate to be confronted with as they get into a project is a steady stream of additional service requests for things that the owner maybe rightly or wrongly, but the owner nonetheless believes should be included in basic services.
And an additional aspect of this with the notice as well, and Brian, you can move on to the next slide where the language is, but an additional component of this notice too is while the consultant is able to, once they give notice to move forward with those services and then try to negotiate it later, but it also does provide notice to the design professional, and where they don't get hit with a myriad of these at the end of the project, which I'm sure we've all seen, where there were unanticipated claims of these things. Part of the intent with that notice was to make sure that it was known in real time, or as close to real time as possible, as opposed to waiting till the end of the project.
So I have a question from Greg that I've actually been chomping at the bit to ask for a little while now, and now's a good time to ask it. And his question is, and so you were mentioning about how we need to be clear about what is and is not an additional service or what is a basic service, and this is on that regard. Do you consider redesign the same as alternates as a set-based design review to determine what brings the most value, and just in parentheses, part of the design process?
This is Charlie Rogers, and I guess I would say first and foremost, as always, it depends on whether the terms of the agreement address that. But generally speaking, I would say no. I think redesign of the type we're discussing, and whether this be to conform with legal requirements, code requirements, or to make sure that the projections provided by the contractor, their estimates and budgets, fall within the owner's stated cost objective, we're talking about redesign in order to alter the documents that the contractor is using to price the work, that a code official might be looking at to determine whether to provide their regulatory authority and approval. This would be, I almost hesitate to use this term, but I'm going to use it almost in the way of a penalty, where the redesign is required for compliance with something that certainly the owner would argue should have been done in the first place. So I distinguish that pretty clearly from alternates, where you're providing two equal options for a choice to be made between them.
And of course, there may be pricing differential for each. Okay. So then indemnity, always a favorite with respect to the negotiated provisions in any construction agreement. And the working group, again, was focused on making sure that there was a consistency with respect to the upstream indemnity obligations. And we wanted to make sure that this provision wasn't taken for granted, and that again, it correlated with the prime. We had a pretty heated discussion on what type of indemnity to include, how broad it should be, because we get various inputs. From the consultant side, you would have a fairly limited indemnity. From the owner's side, you want an indemnity that covers not only negligence-based indemnities, but also breach of contract indemnities, things of that nature. And what we came down on was under Article 10, we have a general indemnity, which is negligence-based for property and personal injury limitations. And we drafted it in a manner that was consistent with jurisdictions that have anti-indemnity laws in place. And I'm sure most of you know what those are, but in the construction context is often different in jurisdictions from the general commercial contracting context, where in the construction context, it's been determined that you can't indemnify someone for their own negligence, right? So many states have adopted this. I think well over 30 states have adopted it. And so in that regard, we drafted it to ensure that it was consistent with those anti-indemnity provisions. Obviously, if you're in a state that doesn't have an anti-indemnity law, you may want to look at this. But when it comes down to it, there is an element of fairness in the way we drafted this as well.
Yeah, and I think the element of fairness is demonstrated by the fact that we agreed that we came up with, this is usually somewhat of a pejorative term, but I don't think so in this context. It's a plain vanilla indemnity, and by that I mean it's really not subject to objection from either perspective. This would be a provision that is typically something that results from extensive negotiation when one starts with a provision that's heavily weighted one way or the other. These terms, limiting it to negligence, limiting it to personal injury or property damage, these are all pretty typical, pretty standard fallback positions when negotiating these among parties that are seeking for something more. So we figured that a fair allocation of risk here, again with the idea that we're looking to be collaborative where we can, would be to just start with the most palatable provision. Understanding, of course, with everything else, that you have to be aware of what's going on upstream. And if in particular, if you've got a delay-related damage indemnity that the owner has insisted upon, that can be something that has to be included or added in order to protect the design professional. But generally speaking, we all felt comfortable that keeping this somewhat plain vanilla would be the best starting point.
And if you refer up from that section or Article 10 to Section 8.2, there is an additional indemnity, and Charlie just alluded to this, which is an indemnity for cost, expenses, liabilities, damages arising out of project delays caused by the errors and omissions of the consultant. This was a topic that we talked about for quite a long time, because it was rather controversial, because it's something that that certainly the consultant would want no part of, particularly as they would be looking to, the more, as Charlie termed it, vanilla indemnity clause in Article 10 as being the extent of what they would want to indemnify the design professional or owner for. The reason why we decided to include it, though, was because through many of the experiences of the people in the working group, we got a consensus that, pardon the pun, that it was going to be something that was more than likely going to be in the agreement between the owner and the design professional. So because of that, we erred on the side of inclusion, so that there wasn't, again, one of these gaps, by making that assumption that it would be there. But as mentioned, these are going to be provisions that even in basic red flag reviews often get negotiated. So we would fully anticipate that the parties do need to take a look at this for their own project and make any tweaks that they deem necessary in their own situation. Okay, moving on. Article 9. So this section has to do with payment, and this is another section that, as we drafted it, the determination was made to make this a fairly bland provision with regard to payment and the payment obligations. And the reason for that was because of the pay if paid and pay when paid dynamics that are out in the marketplace and within each particular jurisdiction. So the way we drafted this was in a way that could be interpreted as a rather benign pay when paid clause. This would be something that you would want to make sure that is consistent with the jurisdiction that you're in, and also with the upstream obligations. Now, for those of you who may not be familiar with these particular provisions, these have been, there's a decent amount of case law out there because there has been enough fighting over these types of provisions. A pay if paid clause is typically considered the strict condition precedent clause, which means that in this context of a contract between the design professional and the consultant, the design professional would have zero obligation to pay the consultant for any of their services if that design professional has not first received payment from their upstream party, most likely the owner. A pay when paid clause is a variation of that and essentially is a softened version, in that a pay when paid clause is that the design professional, in the same example, would not have the obligation to pay the consultant for a reasonable amount of time while they wait for payment from the owner. Now, wherein lies the dispute, as you can guess, is what is this, reasonable amount of time? And of course, you don't get good determination of that during a project. You only get a determination of that later. So you're going to, the upstream party is always going to say, it's reasonable that I'm still withholding, and the downstream party is going to say, no, it's not, unless there's specific case law guidance, which oftentimes isn't great, because the guidance, instead of saying, X amount of days is reasonable, as a sort of a blanket determination, instead they tend to take the more narrow focus of, in this situation, the amount of time that the money was withheld was not reasonable, or was reasonable, whatever the case may be for that specific set of facts.
A situation that's guaranteed to give you anything but clarity is when you have the dreaded case-by-case determination. And if there's ever one out there in the courts, this is it.
Yeah, that's exactly right. That's exactly right. So, certain jurisdictions enforce pay-if-paid clauses, certain jurisdictions don't. So the goal here was that we wanted it to be as bland as possible, and negotiations should be done to make sure that it's applicable to the law in which is governing your particular project. Now, we've got a couple of examples of that. So I'm in, as Brian mentioned earlier, I'm in St. Louis, Missouri. In Missouri, there's essentially quote-unquote magic language that you need to have in order for the pay-if-paid to actually be effective and enforceable. That magic language is something along the lines of, that payment from the owner is a strict condition precedent to the payment obligations of the design professional to the consultant. And in Missouri, that's going to be upheld. Now, you need that language, though, a time consideration, right? Where for instance, if the provision said that that the design professional will make payment to the consultant within 10 days of receiving payment from owner, that's not enough. That's going to be interpreted as a pay when paid, not a pay if paid, because it doesn't have that strict condition precedent type language. Another jurisdiction that I work in regularly is Illinois. They don't have that magic language, but instead their case law has interpreted it to be that it has to be clear and concise what the intentions of the party were, and in order to actually enforce such a provision. And then another state that I work in quite often, New York. That particular state, it's prohibited by statute. So you can't even have a pay if paid. Now, so everything's going to be interpreted as that pay when paid.
This may be somewhat of an obvious point, but the reason this has become such a concern from the design professional's perspective is they don't want to be on the hook to pay their consultants when they have not been paid by the owner for the services that are the subject of the dispute. And that can be a real issue. It's one that I've litigated on multiple occasions, and it puts the design professional in a very, very uncomfortable position if they have not addressed this with their contractual language, and they're looking at potentially being liable for what could be a substantial amount to their consultant when, for one reason or another, the owner has not provided payment. And in particular, if the owner, based upon its agreement with the design professional, has justification for an extended withholding or even not paying for certain work, and the architect has not accounted for that potential possibility with the consultant, that can be a problem for the design professional in a real hurry.
Okay, next slide. Consequential damages, another big one. So as the working group started to look at this particular area, we considered all kinds of different avenues. The full waiver, a limited waiver, no waiver at all, because certainly there are differing views with respect to each party in the contracting chain on what you would want to have within these types of agreements. Now, consequential damage would be, those damages that aren't direct damages with respect to the course of conduct that gave rise to such damage, right? So, for instance, in a situation where there was defective work performed by a contractor, and this is more in the contracting sense, but if there's defective work by the contractor, the direct cost to repair that work would be to actually go in and fix it, right? Whatever it costs, labor, material-wise, to go in and fix it. A consequence to that cost would be perhaps displacement of the owner from that building such that they have to pay rent somewhere else, and that rent would be considered a consequential damage. Owners typically feel that because they're the party that has the most exposure to consequential damages, that complete waivers and mutual waivers between the parties are somewhat illusory because the owner feels that they have exposure, whereas perhaps the design professional and the consultants don't really have that much exposure to such consequential damages. Whereas, the design professional, they're going to look at it as being the middle party in the contracting chain both ways. It kind of depends on what they've negotiated with the prime, and it also kind of depends on what they can negotiate downstream with the consultant. And of course, the consultant's going to want a complete waiver no matter what because they're at the bottom of the food chain, and so they want to make sure that any particular problems that arise, that there is somewhat of a limitation on what their exposure would actually be for those damages that may arise. So we looked at all those possible scenarios, and what we ended up landing on was a compromise. We didn't go with a full waiver. Instead, we went with a limited waiver that excludes any losses that are actually covered by insurance, and then it also excludes any specific damage items that are enumerated by the parties per their negotiation. Now, the thought process was on the insurance was that, one, there should be then coverage there in order to actually provide for funding of that liability. At the same time, if you have a complete waiver, it gets the insurance company off the hook as well, even if there is coverage for that. So we thought that made sense. And then, as far as the specifically negotiated items, while we don't list anything in particular in the agreement itself, the intent there is that the parties can negotiate, and that it's something that they should think about. If there is something out there that is reasonably foreseeable, that they feel needs to be included in there, that they can come to an agreement on in order to properly allocate risk, they should, or they should at least consider that. So one of the best practices, though, and you want to make sure that when you're counseling either party, the design professional or the consultant, one of the best practices is to make sure that that they are consistent, because one of the things that you would not want to have is, if you were in the design professional's shoes, you don't want to have a situation where you're exposed to a greater set of consequential damages upstream to the owner, but there are more constricting limitations downstream to that consultant, because it could leave the design professional holding the bag and without recourse against the consultant for something that they may have caused.
Yeah, and the ultimate, sort of to pull back to 30,000 feet on this issue, what we're looking for here is a means by which to compensate someone for loss, not a windfall, and therefore acknowledging that the architect is 90% of the time going to be forced to agree to a consequential damages provision in its agreement with the owner. I rarely see owners willing to waive those provisions with their contractors or design professionals. Acknowledging that fact, the consultant has to be forced to accept something, and as Charlie explained, the way this has been structured, we allow the parties to focus in on the specifics of what might be included and what might not be included, such that both of them, but particularly the design professional, can look back to the prime and understand what they could be on the hook for and account for those specific items and nothing more in the agreements with the consultants.
All right, next slide, termination. In this particular section, we were thinking about, of course, for-cause termination and termination without cause. And we kept the mutual termination for cause rather brief, really, and really focused on two things. First thing is that we wanted to make sure that the grounds for any such termination would be a material breach of the agreement, which is we didn't want a trivial breach to give rise to ending the contractual relationship and blowing up the project. And the second component of that was the no-fault provision of the initiating party. The purpose of this was in order to avoid any claims of wrongful termination, whereas each party could go then, the consultant or the design professional, they could certainly make whatever claims that they have in order to fight a battle later if needed, but there wouldn't be these additional pile-on claims such as the wrongful termination. The other component then was the termination without cause. And if you notice that this one is not reciprocal, and in fact the design professional is the only party that's able to terminate without cause, and this was done for a strategic purpose. The purpose is because the working group didn't feel that it was fair to allow the consultant to terminate the agreement without cause. Now, the design professional, the justification for having them have this ability would really be, if there is no breach and perhaps the working relationship isn't going well with the consultant, they can always move on and find someone who perhaps they can work a little better with. But of course, they would be the ones in control of that, and the design professional would be the one who can take into consideration upstream issues that may arise, such as delay or anything else that may arise by virtue of that. Additionally, it's very likely that in the prime agreement there would be the ability of the owner to terminate the design professional without cause for a myriad of reasons, such as lack of funding, or the project comes to a halt for any number of reasons. They decided not to move forward, and in that instance, they need to be able to sever and not have the obligation to pay going forward for services that quite frankly they don't need or can't afford. So we wanted to make sure that the design professional had that ability to do that. And the reason why the consultant would not is because they could literally blow up the project and hold the project hostage with that ability. They could use that as a sword in order to elicit payment, in order to strong arm services, depending on the situation and where it was in the schedule and that type of thing. So we thought that was fair in order to only have the design professional have that ability. Now, the flip side of that, though, was that we wanted to make sure that in the event that happened, that there were sufficient levers in the agreement in order to make the consultant at least whole. Not obtain any sort of windfall, but actually be whole. So we provided provisions that allowed for the payment of services through the date of the actual termination, any additional costs of termination, and these should be negotiated and identified up front if possible, because certainly that's, without enumerating those, it could be subject to dispute down the road. And we also left blank a premium amount. And what this was intended to do was not encompass the consultant's full lost profits or something of that nature, right? Because from the upstream perspective, the entitlement to lost profits would be a bit of a windfall to the consultant, right, if they haven't performed that much of the services or whatever. But rather, do a couple of things. One, to disincentivize the design professional from terminating without cause so that it's not just something that's done in a willy-nilly fashion, but then also give some upside to the consultant so that they're not just left with reimbursement of costs, but obviously there would be some lost opportunity by taking this project rather than the next.
Yeah, and one last best practice takeaway here, the category above the premium, the generic and undefined cost of termination. If at all possible, this absolutely should be negotiated and the specific cost identified in advance. Even if we're just talking about estimates, it's very important for the parties to understand the parameters of the cost of a termination for convenience at the time the decision is being contemplated. So dispute resolution, I know we've coming close to the end of our time here, so we'll move a little quickly through these last couple of topics. I think the real important takeaway here, I think everyone agrees that within the construction industry, certainly there's a move toward the attempt to resolve disputes through mediation and then the option of choosing arbitration or litigation. My own experience has been that certainly from client perspectives recently there has been a lot of discontent with arbitration becoming too much like litigation without all the protections built into litigation via the law. So there still is the option to choose here. I think the most important provision we included for dispute resolution, other than allowing for the parties to negotiate and make choices, is to account for and address multi-party proceedings. The nature of construction disputes is that you rarely have a dispute that touch only two parties on the project. There's going to be a need to involve more than just the design professional and consultant, or the design professional and owner, or the contractor and owner, and ensuring the ability to engage in and force the other side to participate in a multi-party proceeding where it's warranted based upon the facts and the parties involved is something we felt was important. Lastly, the ownership of documents. This is one that I know is near and dear to the hearts of design professionals everywhere, and it's one that I think a lot of owners scratch their heads on and don't understand why they can't just own it. Acknowledging that there is that real strong push and pull on the prime agreement side of things, we decided to try and account for the fact that owners really very frequently are going to push for ownership. And again, I'll up front distinguish what we're talking about here. The slide does talk about ownership versus license, but the important point is ownership versus, or ownership or license versus copyright. And obviously we wanted to make sure that copyrights are retained, but looking again from a collaborative perspective, fair allocations of risk and so forth, we decided as a committee that ownership of the documents in question, and what we're talking about are the deliverables, the deliverables, the concepts expressed in the deliverables with respect to the specific project at issue, those become the property of the owner. Of course, they do not have the ability to use them for any reason other than maintaining their own project. Copyright would prohibit them from trying to use them for a different project. The design professionals will retain all copyrights in any circumstance here. Obviously, backing up just a little bit, a lot of this is going to be determined or dependent upon what's in the prime agreement, and that's why the provision at Article 14 starts out by saying that it's subject to the terms of the prime. If the architect, who's the lead design professional, has negotiated everything, including his copyrights, to the owner's surely going to expect and demand the same thing from all of the consultants. So that needs to be taken into consideration, and certainly taken into consideration not just as a practical matter, but in the context of compensation. The other thing that we wanted to talk about briefly here was the issue of when this takes effect. When does the ownership kick in? And we ultimately, after a lot of debate about it, we came down on the side of having that transfer upon final payment. And again, that's one of the issues that seems to perhaps be a nod to the reality of the situation, that the architect is more frequently going to be subject to gaps if they're not able to get everything prior to the transfer of ownership. And thus, in this context at least, final payment allows the parties to negotiate that transfer at the proper time, when it should.
Okay, since we're running on time, why don't we head to the next slide, which is basically just an overview. So, you know, the 250, the working group, the final agreement's out there and available for everyone to use. Certainly our goal was the fair allocation of risk between the parties in the agreement, provide the best opportunity for consistency with the prime, and to make sure that it's simple to use and that it integrates what the group considered to be the best practices and in order to actually reflect real-world scenarios. So hopefully you've enjoyed the presentation. And Brian, do we have any other questions that we need to field?
You know, there's no outstanding questions right now on the queue. If someone wants to type one real quick, I think we can go past our allocated time just a couple of minutes if someone has a question they'd like to ask. If not, everybody's contact information is on the end, but let's give everybody an opportunity to ask a question, if I may. And then let me take this opportunity to both thank Charlie and Charlie for another great presentation that's been really helpful and valuable, and I got some positive comments that were not questions, but saying that sharing some of the the difficulties in trying to define the scope was in particular helpful. That know that everybody struggles with that type of concept. Let's see here. I do have a question here from Greg. In the Consensus Docs 250, are fees a percentage of the cost, fixed fee, or hourly? And I know we have a payment slide here. And, I should mention that we will be providing everybody a free sample who attended today's webinar as well. But do you guys want to comment on that question as far as the cost or how it's determined? I should say fees.
Sure. So in the agreement itself, it's set up as a lump sum arrangement. So under compensation, which is Article 3, it allows for the full compensation is going to be X, right? Well, actually, I'm sorry, on the following basis. It allows for fill-in. I'm sorry for misspeaking. It allows for fill-in of any methodology that you want to use. The payment provision that we were discussing earlier actually doesn't cover that. It's actually Article 3. So again, this is meant to be rather flexible. And we also have a line in Article 3 with regard to the compensation for additional services and what basis that is on. So again, the goal is to be flexible. This way you can add your own terms for that particular cost methodology.
Next question is from David, and maybe my favorite question is basically, is there a way to purchase Consensus Docs? And then there's a question about, is there a moderate way? And I can answer this question and have some good news in that regard. There is a new subscription package that we've created specifically for design professionals. And if you go to consensusdocs.org and there's a quick purchase, we've made it one of the least expensive subscription packages to encourage usage. It includes the documents we've discussed today, the 250, the 240, the 245, qualification statement, and actually I think it's almost 40 different documents. And that right now is a price of $349 for an annual subscription, unlimited usage for 1 year, annual being 1 year. So thanks for that question, David, and hopefully that answers that question. Let me go to another question that we have right now, if you can bear with us. How are the design professionals' errors and omissions insurance requirements flow down to the different consultants? From Reggie.
Well, I think the easiest way to answer that question is that each of the design professional and the consultants are going to have their own requirements. So I don't know that it's necessarily a flow down where the amount is allocated between them as much as it is a flow down of the requirement of the not just the professional E&O coverage, but other coverages that the owner may mandate, as well as specific amounts. So if, for example, the owner simply says professional liability insurance of $2 million per claim, $5 million in the aggregate, applicable to design professional and its consultants, then each of them is required to have that amount. More sophisticated insurance packages frequently acknowledge and recognize the disparity between policies carried by large architectural or large engineering firms and those that might be carried by some specialty firms that engage in consulting services and may have different amounts required for each discipline. But as far as there being an allocation of one set amount, I don't think that typically happens. And often it is that there is just a flat requirement of professional liability coverage in X amount per claim and X amount per aggregate, and that would mean that not just the design professional but all of their consultants must comply with that requirement.
Great. Another question from Joe is, does this document work well with the AIA Prime Design Professional Agreement?
I think we can answer that first and foremost by saying that many of our experiences that led to some frustration were born out of the clients utilizing the, well, I guess what's now the B101 and the C401. Not that there's anything wrong with those documents. I don't think if the proper attention is given to them by the parties involved, I don't think you're necessarily handicapped in any way or you have additional problems to surmount. They certainly can be used to arrive at a desirable result. I think for the purposes of this discussion, and certainly the context in which the 250 was developed, we were trying to address some of the issues that often popped up when clients were using those documents. So I'd like to think that maybe the 250 solved some of the coordination issues that existed between those documents. At least that's the hope.
Yeah, and I think that just from an overall perspective, I think you'd have some issues utilizing this agreement without some modification, just because of the way things are, because of terminology, and of course, while we brought in certain parts of provisions from the upstream 240, 245, that language is different than what's set forth in the AIA set of documents. So you'd really have to spend some time going through and making sure that there is consistency there for it to work at all, I would think.
One thing I like to mention is that I encourage people to use ConsensusDocs. I think it's a positive thing. But even if you're just using this document to modify your manuscripted document or negotiating for certain provisions, that's a step in the right direction than not doing anything. Last question that we're going to have time for today, and thank you for everybody for staying a little bit extra and taking time from your busy schedules for today's webinar. But it is about money, and everybody cares about payment. And here's a question about reimbursables from Lauren. How does ConsensusDocs handle reimbursable expenses?
Consistent with Charlie's earlier answer, it provides the flexibility to deal with it in whatever way the parties feel is appropriate, and typically that way is however it's mandated in the prime agreement. That's one that's not really open to much flexibility unless the design professional simply wants to assume some risk with respect to reimbursables. But very typically that treatment is going to be dictated by the terms of the prime agreement, and whether the design professional has thought ahead to account for some percentage on top of consultants' reimbursables or going beyond just reimbursables, consultants' additional services, for example, is something to consider on the front end. But once you get to the consultant design professional agreement, again, that's an issue that's very likely foreclosed with respect to coming up with something creative, absent the design professional being willing to go out a bit on a limb, because they're going to be precluded from anything other than what's in their agreement. And really what they're doing with reimbursables is simply passing them along.
Yeah, and the default in Section 3 is paid at their actual cost, right? So no markup. So as Charlie mentioned, Prime's going to govern. The default, though, is going to be actual, and we allow the flexibility to where it's essentially a blank Exhibit C, but if you provide something different there, that's where it would be negotiated and placed, and that's procedural within Section 3.3.
Excellent. Well, as I mentioned before, I want to thank everybody. I want to thank our speakers for doing an excellent job. I want to remind everybody that you will receive an email with both the survey for today's webinar, but also materials that will give you the full audio and the PowerPoint slides and a sample of the ConsensusDocs 250. There's a lot of additional information on the website. We'll actually have the audio for this webinar on the website as well, under, I believe it's audio, under ConsensusDocs resources and then audio recordings. So you'll look for that in your email. Please take the survey, but it's always on the website along with a lot of other free resources on the ConsensusDocs website. Thanks again, and everyone have a wonderful rest of your day. Thanks, guys.
Thanks.
Yep, thank you.